Hello and welcome to the Courthouse, your #1 legal talk show where we get to learn the law in plain, simple and entertaining language. Different aspects of the law spring up every day and we keep you abreast. I am Itohan Olomu-Agbodo. But first we'll go on a quick break. Stay with us.
If we have to give you anything, then we have to give you everything. Love Plus Channel 465 is simply the best. Because we have something for every member of the family. So dads, keep the team spirit going on with our intriguing sport highlights and reviews. And moms, cooking is never boring when you have our intriguing drama series. And for all your lovely kids, just sit and enjoy. This, and oh this. I told you, we have something for everyone. Because we are indeed all about you. So keep it locked on Love Plus Channel 465 on Star Times.
You're welcome back. This is the Courthouse, and this week we are taking a look at something very, very contemporary. We're looking at data protection laws, we're looking at internet laws, things that have to do with social media, things that have to do with the online presence and online protection, things like that. And this week we're joined by a legal practitioner who is going to be telling us all about what we need to know about this data protection law and things like that. He is David Amakiri. So good to have you in the Courthouse this week.
Thank you very much.
It's been a while.
You have refused to call me.
We want to use the opportunity to say congratulations on your new status as a married man.
well, I've been married to Jesus, so it's not really new.
You're married to a woman now. So data protection, first of all, what do we need to know? What is data protection all about?
Okay, I think, first of all, I'll start by saying data is any information that can be obtained about anybody.
Okay.
So data can be from mundane things like your name, your address, your picture. It could also go to things like your email, your password,
yes,
your ATM, your ATM card number, your ATM,
online banking.
Yes, your online banking details. It could also go to things like your habits, what you like eating. Information about what you like eating is data. When you sleep, where you go, people you talk to, things you like to watch. So any information that can be obtained about anybody, colors you like, how many children you have. So data is
life.
Is now life.
Because that's what we hear on ads these days. Data is life.
Data is indeed life.
Now you've mentioned these things because we use this thing every day. We use data every day.
Every day.
And this time around, it's mostly on social media. It's mostly on our mobile phones, on our mobile devices and things like that. So how do we protect this data? Or is there any law protecting our data out there in cyberspace?
Okay. I mean, all over the world, the issue of data protection is now a front burner issue. Somewhat is new, but somewhat again is not new.
It's not new.
Because if you look at the U.S. media today, the key issue is on the Mueller reports, Russian intervention in U.S. election. It is all about data. Okay, so in that sense, it is new. But again, it is not new because for long we've had names, we've had ID. But what makes it relevant today is the rise of the internet, the rise of smartphones, and then importantly, the rise of social media. Okay, so these factors have made data protection more relevant because social media, for example, have changed the paradigm of what is now important to people. Is my picture, for example, as important as the places I go on the internet? So in that sense, it is now a very contemporary issue. And from a legal perspective, lawyers are concerned, legal practitioners are concerned, regulatory bodies are concerned. I think one of the in a country like Belgium, for example, they've had a kind of protection law since the 90s. But again, that law did not take into cognizance the rise of the internet. And so then, with the EU, there's now a contemporary platform for data protection for EU subjects, and then companies outside the EU. By EU, I mean the European Union. So companies outside the EU that hold the data of EU subjects. So companies in Nigeria, business entities in Africa have somewhat been affected by that kind of legal regulation, legal legislation. The EU in 2016 came up with the General Data Protection Regulation, which was to provide a holistic basis of how data collectors can use data. So if you collect the data of an EU citizen, what do you use it for? How do you use it? How long can you use it? So those were the issues. And so because of that, African countries are now looking at, perhaps we also need to protect our own citizens.
Yes.
Because if an EU citizen is in Africa, is in Ghana, is in Nigeria, there's a law that says how I can treat the data of that EU citizen. Perhaps we need to look at African citizens in that way.
Because now you're mentioning the EU and other countries and things like that. For instance, the WikiLeaks issue was also about data.
Yes,
and,
it was about how access to governmental data. Julian Assange and
yes.
The espionage issues. So those were about, but again, in that sense, governmental data is protected by several other regimes. Like some countries have Official Secrets Act, where certain information that are necessary for national security are not to be in public domain.
Okay.
So in that kind of global sense, government data is somewhat protected. And then so you now come to the issue of, if government data is protected, what happens to the data of businesses? And so the way the law begins to look at it is that the data of businesses are protected by other body of laws. I give you an example. When you've heard something like a non-disclosure agreement. Okay, that non-disclosure agreement is meant to guard against the misuse of corporate data. So in that sense, corporate data is protected when a corporate entity goes into a relationship with a third party. And then there are laws around trade secrets.
Yeah, I was going to ask you about trade secrets.
Yes, laws around trade secrets. So when you get confidential data about my business, there is a way you can use it and there's a way you cannot use it. So it's protected in that sense. So then, but when you come to the individual level, that is where it becomes tricky.
Okay. Before we go to the individual level, we want to take a quick listen to our report on data and data protection, as well as our legal nuggets. We'll be right back. Stay with us. There is presently no specific or comprehensive data privacy or protection law in Nigeria. The only legislation that provides for the protection of the privacy of Nigerian citizens in general terms is the 1999 Constitution of Nigeria as amended. Section 37 of the Constitution provides that the privacy of citizens, their homes, correspondence, telephone conversations, and telegraphic communications is hereby guaranteed and protected. There are, however, a few industry-specific and targeted laws and regulations that provide some additional privacy-related protections. One such industry-specific regulation is the Consumer Code of Practice Regulations of 2007, issued by the Nigerian Communications Commission (NCC), that is the regulator of the telecommunications industry in Nigeria. The NCC regulation provides that all licensees must take reasonable steps to protect customer information against improper or accidental disclosure and must ensure that such information is securely stored. It also provides that customer information must not be transferred to any party except as otherwise permitted or required by other applicable laws or regulations.
Unlike the Constitution, the application of the NCC regulation is not restricted to Nigerian citizens. They apply to all customer information relating to customers of any nationality that use a licensee's network. The National Information Technology Development Agency (NIDA), which is the national authority responsible for planning, developing and promoting the use of information technology in Nigeria, has also issued guidelines on data protection. The NIDA guidelines prescribe the minimum data protection requirements for the collection, storage, processing, management, operation, and technical controls for information, and is currently the only set of regulations that contain specific and detailed provisions on the protection, storage, transfer, or treatment of personal data. With respect to laws that provide specific data privacy protections, of primary importance is the Child Rights Act of 2003, which regulates the protection of children, that is, persons under the age of 18 years. The Act limits access to information relating to children in certain circumstances. The provisions of the Freedom of Information Act of 2011 also impact on the protection of the information of individuals in Nigeria. In addition to the foregoing, the Nigerian courts have also provided some guidance on this matter. One concern that often arises for employers in the absence of specific data protection legislation is in relation to the collection, storage, processing, management, and treatment of personal information of employees. This concern, which is common amongst multinational corporations that usually have a centralized database where the employee's personal details are retained, arises from the fact that the language of Section 37 of the Constitution is very wide and could be breached in circumstances where it can be established that personal information such as the names, telephone numbers, and addresses of employees who are Nigerian nationals have been published or disseminated without the consent of such individuals.
You're welcome back. This is the Courthouse, and this week we've been talking about data protection, and we're still with David Amakiri, who's been talking about how data should be protected. You were talking about trade secrets of businesses, governments, and protection of their secrets in public domain and things like that. Now, you are going to mention individual aspects of this data protection. How do I get my own information protected? Is there any law protecting me, for instance, because I go online, I'm doing some shopping online, I go online, I'm putting my online banking password, I'm putting my email password, sometimes they're asking save to the site and things like that. Most of the things we do these days are online. So as an individual, what protection do I have?
Now, that's interesting. You know, you mentioned online. So online is the biggest market for data.
Yeah.
But also there's data offline. So for example, if you go to, let's say a mall, or let's say you go to a health management organization, and you say, please, I want to get a dentist, and then they ask you for your name, your address, and then they take a photo of you. That is also data.
Yes.
Okay, so, but the law struggles. The law as it is today in Nigeria struggles with dealing with data. So from some certain perspectives, the law is beginning to look at data strictly from the online position. So for example, if you log in your ATM PIN on a website, there are rules around what protections the bank should put in place. For example, the 3D Secure, the third level authorization, where, for example, you put in your card details and then they'll have to send you a number for you to impute again. That's like a third level authorization.
Okay.
So the Central Bank of Nigeria as a regulator have provided rules around those kind of issues. Again, the Central Bank of Nigeria regulates the way banks use your personal customer data. You know this KYC, know your customer, and then they have all your details on your BVN and all that. So for banks, there's a way they can use your data. But for companies like Konga, for example, Konga.com, there's really no specific law that says this is how they can use their data. But very, very, very recently, the National Information Technology Development Agency, the NITDA, which is the foremost government agency in terms of technology development in Nigeria, came up with a kind of regulation, a legal regime for how data collectors can use data. So under that regime, it looks at data collectors in two ways. You can either be somebody that collects data, you store it, so you are a data processor. You collect data, you store it, you send it. Or you can either be a controller, in the sense that you collect data, you don't just store it, you determine how that data will be used. So you can say that data collected will be used for telemarketing. Okay, so now this new regime has created certain regulations around that. So for example, if you collect data for a specific purpose, if you collect my data, my phone, my email address to register me for a program, you can only use that data for the program for which you collected it.
Because now that you mentioned that, a lot of times we see messages just popping up in our phones. Now that you mentioned it, so who do we complain to? Is it the Consumer Protection Agency? Because a lot of messages just pop up on our phones, pop up on our mobile devices. How do they get our data? How do they get numbers, phone numbers, for instance? Because that's one of the most common. Subscribe to this, subscribe to that. What do we do about that?
Now, basically, they get your data because they buy it.
How?
There are people who sell this data, who have it. Somehow, you have filled, for example, of course, the telecommunication companies, they have your phone number. Okay? So there can be data theft through the telecommunication companies. Okay? But somehow you have filled some information online. A lot of people use the application they call Truecaller these days.
Okay.
So through applications like that, your data is harvested from your phone. And then the Nigerian Communications Commission, that's the NCC. They passed a regulation, I think about sometime 2015, 2016, on this issue of calling, because you are just on your bed, your phone rings from an anonymous caller. So then they put in that do not disturb regulation in place, where customers can now opt in, not to prevent them from getting these third-party advertisers. So once you opt in for that do not disturb, you cannot get all those anonymous calls, all those telemarketing text messages. Okay. You should not get it. Okay. And then the NCC also went as far as providing a toll-free line that people can complain that I've been getting so much of text messages despite the fact that I use do not disturb. Okay. So from that perspective, I think that was a pragmatic approach by the NCC.
Yeah, that's quite laudable. But now, back to the laws again. So is there any body of laws that actually regulates data in Nigeria, for instance?
Okay, so first of all, I like to think that the European General Data Protection Regulation applies in Nigeria because it applies to EU subjects in Nigeria. So Nigerian companies are subject to it to the extent that they are holding the data of EU citizens.
But has it been domesticated?
Well, it hasn't been domesticated in the sense of being a law that is enforceable in Nigeria. But it is operational in the sense that it is a law that can be enforceable against a Nigerian entity. Okay. So the GDPR is one of them. Then from a legislative perspective, we'll be looking at the National Information Technology Development Agency Act, which creates that body that ought to look at protection of information technology in Nigeria. Then you also have the Cyber Crimes Act,
Okay.
Cyber Crimes Prevention and Prohibition Act. So what that act does is, where it targets the issue of data theft, criminal data breaches. So where you obtain somebody's data for the purpose of committing a crime or with a criminal intention, then that law catches up with you. So that is one of them. Then I've mentioned the CBN regulations, but it's applicable to financial institutions. And then I've talked about the NCC. The NCC, apart from the do not disturb issue, they also have the
toll-free lines.
The toll-free lines. Then this thing about registration of SIM cards. There's a regulation around registration of SIM cards. So when you collect people's data upon registering their SIM card, there's a way you can use it and there's a way you cannot use it. For example, you cannot sell the data you collect. If you collect the person's name, the address, his location, you can't sell it.
Okay.
Okay?
Except, you're going to say except.
I mean, the exceptions to use of data generally is, one, consent, where the data subject consents to the way you want to use it, or where it is it's being done for the prevention of crime.
Okay.
So, for example, the police can go to MTN and ask for your call log even without your permission because they are trying to apprehend a criminal or prevent crime
from being committed.
Yes, so that's in that sense. And then I talked about the data protection regulation that the Nigerian regulator brought in. It gives data subjects rights like the right to be forgotten. That issue that came up. Can I choose to be forgotten?
Please tell us a little bit about the right to be forgotten.
The right to be, it basically talks about that a data subject has the right to demand that a data collector deletes his entire data. So you have a right to ask Google to delete your entire data from all Google applications, from their search engines, from everything. There are other people who say, should such rights exist?
No, I think it's actually a very good one. The right to be forgotten. So you now become totally anonymous anyway.
But there's a dicey situation there.
Yes.
There was this, was it Christchurch or something in New Zealand, where there was a terror attack and the attacker was virtually videoing it on Facebook and videoed for about 17 minutes. So in that kind of a case, for example, if he videos it and then makes a request and while this videoing is live, so everybody has seen it, can he then make a request to Facebook to say, I want to be forgotten?
But you actually made an exception already. You said if there's maybe a crime or illegality involved, that's an exception. So in that case, really.
You can say, well, so those are the things that agitate the minds of...
Okay, any last words, anything you want to see in terms of data protection, especially in this part of the world?
I think in this part of the world, there are certain things we need to take into cognizance. Okay. For example, our law needs to step up on the issue of special data. So data as regards race, as regards sexual orientation, those are special data that the law does not really deal with properly. And those are areas where advertisers are increasingly targeting. Then the issue of automatic decision making. So for example, you just log into a site automatically, you don't know you are now subject of certain privacy policies. Our law does not really cut that aspect. Then the data of children, because these days there's a lot of apps for children these days. So data of children have not really been looked into. So those are kind of areas that we should begin to look into.
Quite interesting. Thank you so much. But I told you are actually an old panelist.
Your Babu.
Yes, a Babu.
Your Babu.
You actually mentioned it. You have to give us
in area of data protection, there's no Latin maxim.
Give us anyone.
Well, I'll just say ubi jus, ubi remedium. Because where there is a right, there's a remedy.
Right.
And that is what data protection laws are looking to do today.
Okay, so let me stay with ratio decidendi. It's a decision by the court. It's an aside, maybe a comment made by the court. You get to find out more Latin magazine about book segments. Stay with us. Thank you so much for sending your questions. Keep sending those questions in. And at this time, we must say thank you to David Amakiri for making this episode quite interesting.
Thank you for having me.
Okay, so if you have comments for us or you want updates on our website, you can log on to www.loverplus.tv, and we have numbers that will be shown on your screen now that you can send your comments to or your questions to. I am Ito Olomu-Agbodo, and I say, don't just get mad, go get a lawyer. Bye for now.